Hello, this is Professor Neil Hamilton from the Drake University Agricultural Law Center. I want to welcome you to this installment of our series, Law for Landowners, 10 Things You Should Know. Our topic today concerns farm leasing and how to introduce ideas of conservation in farm leasing relations. The first point to think about is the importance of farm leasing. In thinking about the state where we are today, Iowa, farm leasing has always been a critical part of the agricultural story in Iowa. While the amount of land being leased and the type of leases commonly used have changed over time, today we have over 12 million acres of crop ground, or over half the crop ground in the state, farmed under some form of lease. This is what makes farm leasing relations and the typical provisions that you find in a farm lease a critical point in Iowa's agriculture and in understanding how our land is farmed. Farm leases in Iowa are typically for 1 year, even when they're in writing, though of course they could be for longer terms. Most farm leases today are cash rent leases, though you still may find some that are crop share. Whether a lease is a crop share or a cash rent typically relates to the method whereby the rent is calculated and the way it's paid. Oral leases are still somewhat commonly used in agriculture, and oral leases are only binding between the parties for 1 year under a legal doctrine called the statute of frauds. Now, the truth is that even though most lease relations may only legally be for 1 year, the actual relations may continue much longer than that because the parties continue the leases under the same terms and conditions, or they renew them for many years to come. The second point to think about is whether or not there's some type of statute that might apply to farm leasing practices. In Iowa, the most important statute is a provision that makes September 1st the statutory date for providing notice of changes in farm lease relations. Now, the September 1st statutory date applies to both landlords and tenants, meaning that if you want to terminate a lease for next year, you want to change the tenant, or if you're the tenant and you want out of a lease, you need to provide statutory notice before September 1st. The same thing's true if you want to somehow change the terms of the lease, such as trying to alter the amount. Now, the parties can always agree to make those type of changes at some point later if they can come to a mutual agreement. But the important point about the statutory date is that after that period, no changes can be made unilaterally. There are some exceptions, and one of the most common exceptions is if there's a failure to pay the rent, the lease won't continue. But otherwise, if a lease hasn't been terminated or altered prior to September 1st, it will continue under the same terms and conditions for the next crop year. And under Iowa law, the crop year begins on March 1st. The third point to think about with farm leases is, well, what type of terms can be in a lease? Well, the truth is that the parties can include in a lease anything that they can agree to, as long as it's legal. But if you look at, for example, typical form leases that you might find, for example, the Iowa Bar Association has a sample farm lease form that is commonly used. Well, those lease forms may include dozens of different clauses, and they're designed to deal with most of the questions that could arise between the parties, such as the duty to return the property at the end of the lease term, the calculation of the rent, when it's due, whether or not there's a lien against the crop or some other type of security interest. And so the point to think about with a lease and the lease terms is that the parties can include whatever the provisions are that are important to them. And one of the reasons that people oftentimes use form leases is that those forms have been refined over time to try to include language that would deal with many of the predictable questions that can come up. The fourth point to think about with farm leasing, particularly as it relates to conservation, is, well, what should I include? Well, of course, most people spend a fair amount of their attention to farm leasing on the economics. How much is the rent? What can I expect to either pay if I'm the tenant, or what kind of revenue might I receive if I'm the landlord? But I think everyone knows that there's more to good farming than just dollars and cents and how many bushels might have been produced. And certainly caring for the land and land stewardship is an important part of that. And so that's why one of the important components that people can think about in a farm lease is how it addresses issues of conservation. So for example, if you're the landowner and you have certain goals for how you want your land farmed, there's no reason why these can't be addressed in the lease. For example, do you want the tenant to have a soil conservation plan? Or are there certain types of farm practices that you want to see them adopt? Similarly, if you're a tenant and you're interested in implementing conservation or water quality practices, thinking about how you can discuss those with the landlord and perhaps include language that addresses them in the lease is part of the opportunity. For example, if you're interested in planting cover crops and trying to deal with water quality, one of the questions you might have is, well, who'll pay for them? If you're interested in what might be a longer-term crop rotation, then you may need to visit with the landlord about whether we can have a longer-term lease rather than just an annual year-to-year lease. Again, parties can include any terms that they want to in their lease agreement. It's a question of their communication and being able to come to some type of mutual understanding. The key about conservation in a lease is that there's not necessarily one correct answer to how these issues of how conservation should be handled or whose responsibility it is should be addressed. Instead, the key is it's important for the parties to have an opportunity to discuss these, and the lease agreement is a great opportunity for that type of communication. Well, a fifth point to think about, particularly with conservation and farm leases, is how is the issue of conservation typically dealt with in traditional farm lease agreements? Well, there are several answers to that question. For example, if you have an oral lease, it's not common that the parties would have actually perhaps even discussed conservation. Even when there are written leases, the parties may not have expressly discussed conservation, but still, the typical provisions in a bar form lease, for example, are going to have language, or will have language that deals with conservation. For example, there's oftentimes what might be called a proper husbandry clause, which says that the tenant will exercise caution and care and try to obtain the highest crop production possible, while at the same time maintaining the fertility or productivity of the soil. You may even have more specific provisions. For example, you could have a provision that actually says that the land will be farmed subject to a conservation plan issued by the USDA or by the county Soil and Water Conservation District. Again, parties can agree to whatever they want to or whatever they can agree to, but many typical farm lease forms haven't historically addressed the issue of conservation, though that could well be changing as it becomes more of an issue and more of a concern on the minds of parties. On the issue of typical farm lease provisions, you typically have one that'll also talk about harvesting the crop and a duty to harvest it on a timely basis. You may even have one about care of the soil that will relate to spreading the manure on the porous soil and doing other things to try to enhance soil fertility. And so I think the key from the parties to the lease standpoint, particularly the landlord, is to read the provisions that might be in the lease form, if in fact that's where you're starting with, and see whether or not they accurately and adequately carry out what your goals might be. If they don't, you can always include more specific provisions that might relate to conservation or to the farming practices that you'd like to see on your land. So a sixth point to consider is, well, what might happen if the actual lease agreement that was created by a landowner has more specific provisions about conservation and stewardship, and in fact a dispute arises over whether or not the tenant met those expectations. Well, the Iowa courts have looked at a number of cases that deal with this question. And in one case in particular, the Quaid case, the landlord had included a number of relatively specific provisions in a multiple-year lease agreement. They dealt with the amount of atrazine that could be applied, a limitation on the number of acres that could be planted to corn, the requirement of having a oat crop as a nurse crop. And early on in the relationship, the parties had a conflict. And I think it's fair to say the landlord had decided that this tenant wasn't going to be able to meet their expectations. And so in fact, the parties terminated the 3-year lease agreement after the first year and released each other from any claims of damages for the future years. But then the landlord sued the tenant and claimed damages for what the tenant had done to the farm during the year that the tenant was actually in possession. For example, the landlord requested damages for excessive soil erosion, for damages to a crop because of atrazine carryover, damages to an alfalfa crop because it was harvested too late and you had freeze die down of the alfalfa crop. And after the case was heard, the court actually found for the landlord and awarded damages against the tenant. It only amounted to several $1,000s, but still it was a difficult situation for the tenant and showed that in fact courts would be willing to enforce these very specific lease terms. Now the tenant had a defense. The tenant said, I just farmed the farm as I normally would have, and what I did was reasonable. And the tenant claimed to hold them responsible for damages for soil loss really would make all tenants the possible guarantors of their landlord for any soil loss. But the court rejected the defense and held that in fact the damages that the farm experienced and the level of soil loss wasn't reasonable and in fact violated the terms of the lease agreement. The seventh point to recognize about leases and conservation is that cases like Quaid that involved very specific provisions in the lease relating to caring for the land and a court looking at how the land was farmed aren't very common. It's more common that people would have either an oral agreement or a standard bar form lease. Then the issue becomes, well, how will the courts and the parties actually address what might be conflicts about conservation? Well, clearly, one of the best ways to address this issue is to discuss it up front so that the parties have a mutual understanding of the expectations. And I also think that other court cases have shown that the court is willing to say, well, there may be two different ways of thinking about how you might farm a farm. And unless a landlord can show that the conduct was unreasonable or resulted in significant damages, it may be unlikely that a court would hold a tenant responsible, particularly if how they had farmed the land was reasonable and in fact was what might be commonly done. But important issue to remember here is that if you do have specific provisions, things that you don't want to have happen, for example, I don't want this pasture plowed up, and you have a provision in the lease that provides that, that should give you sound legal grounds to make sure that your expectations aren't in fact violated. An eighth point to consider about farm leasing as it relates to conservation is, well, what happens if the lease is silent on this? Or, for example, it's an oral lease. What is there for the court to actually interpret? If the parties didn't include anything specific or even enter into a written agreement, how could we expect the court to resolve some dispute over how the property may have been farmed? Well, one of the questions that comes up in this regard is whether or not there's some type of implied covenant or expectation on the part of the landlord in terms of what the tenant should do. For example, regardless of the type of lease, whether it's for a car or a farm or an apartment, there's an implied covenant that the tenant will return the property at the end of the lease period. And so that whole idea of having some type of implied obligations is not uncommon in interpreting leases. Well, the ninth point and the question that comes up is there an implied covenant of good husbandry that's associated or attached to a typical farm lease, even an oral farm lease? Well, the Iowa law on this issue is somewhat undeveloped, but the Iowa Supreme Court, in one important case, held that yes, someone who is in the position of a farm tenant has an implied duty of good husbandry that can be used to determine whether or not they have unlawfully and unreasonably damaged the landlord's property. The case didn't involve a farm tenancy. Instead, it involved a dispute back during the farm crisis over the ownership and possession of a piece of land. And after the people who were the rightful owners were able to obtain repossession of the property, they discovered that it had been significantly damaged during the period while it was out of their possession. And they brought an action against the person who had farmed it, who'd plowed it up and down the hillsides, and it resulted in over 50 tons of soil loss a year. And their argument was this person should have been responsible for the damages that they did. Unfortunately, the court held that they weren't able to factually prove the damages, but on the legal question, the court said the legal standard meant that yes, there was this duty if the damages could be proven. And so many people believe that the Iowa law does provide for an implied covenant of good husbandry. And even if it doesn't, I think it's important that the parties who are involved in something like an oral lease should recognize that there is this idea of a duty. There's a duty under our soil conservation laws, for example, and there's a duty that's owed both to the owner of the property and arguably to the land itself, to farm it in a way that protects its future fertility and sustainability. Well, the 10th and final point to consider is what other alternatives are there for landowners and tenants to include issues and goals of conservation in a farm lease? Well, as we've mentioned, there's the opportunity to include specific expectations. For example, do you want to see the land farmed under a conservation plan? Would you like to see the nutrients applied under some type of nutrient management plan? So leases can include those type of very specific provisions. But in addition, there are other issues to consider. For example, I think you could argue that a longer-term lease relation makes it more possible for someone to implement conservation, whether that's longer-term rotations or whether it's the incentive to install what may be more permanent conservation practices, looking for ways to make sure that land is farmed in a way that's the most suitable or reasonable for the land, maintaining grass waterways, maintaining vegetative buffer strips, being able to take out those least productive acres that maybe aren't going to produce a crop profitably, but which are going to consume inputs like nutrients, providing a way to reduce those out of the amount of land that is being charged for rent, but instead to use those for habitat, for example, would be one of those ways that the parties could introduce more conservation in the lease. The point here is, where there's a will, there's a way. The beauty of the law and of entering into private contracts, which farm leases really are, is that the parties have the freedom to contract, the autonomy to include whatever provisions they desire that carry out their expectations. If you're interested in conservation and how good farming practices, water quality protection, wildlife habitat, whatever the goal may be, can be included in a farm lease, there are ways to go about seeing that gets done. Thank you for listening today. This has been Professor Neil Hamilton from the Drake University Agricultural Law Center with this installment of Law for Landowners, 10 things you should know about farm leasing and how to include conservation in a lease agreement.